Welcome to the Legal AF podcast. And I was just looking over my list with my guest co-anchor tonight. It is, you can't read my handwriting. I can barely read my own handwriting, but it is a pretty extensive list, which means we've turned the corner in the Trump administration now that we've gone past whatever day 550 or whatever it is. And now we're into that accountability section where Donald Trump is acting out against his political rivals or critics on a regular basis. Now he's got his guy running the Department of Justice. So all the things that even Pam Bondi held them back from doing, all those barriers are gone. It's all gas and no brake. And federal judges now, having spent 2 years learning the playbook, being forced to learn the playbook, know how to respond. So we're seeing a lot of developments in cases, including in the ones, talk about chickens coming home to roost, those private plaintiff cases that Donald Trump likes to bring. Well, I'm the president, but I'm not really the president when I file this lawsuit. Blah, blah, blah. And he always files them down in Miami, and it's always a dead bang loser. So we're going to kick it off with, first I'm going to introduce my guest co-anchor. He's done Legal AF with me and on the channel before, but never on the Midas Touch version. Adam Klasfeld of All Rise News. How you doing, Adam?
Doing great. Thanks. Great to be here, and thanks for having me, Mike.
You and I have been doing regular Legal AF Substack lives once a week. We made that commitment. We took a little bit of time off while I've been traveling, but and we got sort of a fun little energy going there, a little vibe going there that we enjoy. And I said, Karen Freeman Ignifilo is unfortunately not feeling well today, and I said, let's bring in Adam Klasfeld to sit in. And thank you for being so generous with your time and our audience.
Well, thank you. I'm looking forward to it.
Yeah, and for people who only read Adam Klasfeld, but don't know what he looks like or aren't following his amazing videos that we do over on Legal AF YouTube channel. This is Adam Klasfeld of All Rise News. He is one of the leading legal commentators, and not just from afar, like from the privacy of his own, den or bedroom. He's in the courtrooms. He's in the courthouses. I can't tell you how many, and he and I joke about it, how many windswept remotes I have with Adam Klasfeld out in front of, regardless of the weather, out in front of some courtroom or some courthouse after having gone in to watch the hearing. I think that's one of your competitive advantages, Adam, that you bring to Midas Touch and Legal AF, and I thank you for it.
Yeah, my pleasure. I think it's important for people to understand how the news gets out there. It's by being there. It's by looking at the public record. It's by listening to the parties and the judges and seeing the expression on their faces. It's history in the making. And I feel privileged to be able to see the history-making cases, whether it's Trump's criminal trials. I was there in Manhattan criminal court when it happened, when those 34 convictions came down. I was there in the District of Tennessee, Middle District of Tennessee, when Kilmar Abrego Garcia got his case dismissed, and all of the hearings for vindictive prosecution. You bet I'll be there for James Comey and other cases as well.
Well, it's funny that you mentioned James Comey, because one of the first acts, let's turn to Blanche for a moment, shall we? His first official act was to pick who was going to swear him in. And what a poke in the eye to the rule of law to have chosen Emil Bovee, his longtime puppy that followed him from every position he ever had, ultimately set up shop in a two-man office to represent one client named Donald Trump and rent space in Donald Trump's building on 40 Wall Street, represented Donald Trump in all of those criminal cases, even touched on the E. Jean Carroll case. And also a guy who, before he got elevated to the Third Circuit Court of Appeals, was accused by a very well-respected whistleblower, Erez Ruveni, of having told the Immigration Litigation Department of the Department of Justice at the top of the administration that they should look federal judges in the eye and tell them to, what's the phrase I'm looking for, Adam? Go fuck yourself if they try to provide oversight over Donald Trump's removal policies under the Alien Enemies Act, for which he had to answer, Emil Bovee, to Adam Schiff, the senator, during his confirmation hearing. This is your first official act, to have the guy that probably should be impeached himself for what he did in the Department of Justice for the short time he was there, be the guy to swear you in? What did you make of that?
Well, first off, the fallout of all of that is ongoing. There is still the Judge Boasberg inquiry that was litigated in the DC Circuit, and so to have both of those figures to choose Emil Bovee as the guy who's swearing him in, because Todd Blanche was at the time a deputy attorney general when all of that was going down. So there's the contempt inquiry wrinkle of it, but also the kind of oddly appropriate side of it. You noted they were both Donald Trump's personal criminal defense attorneys, and they were both there to defend him in the Manhattan criminal trial, and they both lost. Their advocacy resulted in 34 criminal convictions against Donald Trump. So that was the symbolism they went with, the losing team in Trump's criminal trial at the swearing-in ceremony.
It's like the Black Sox scandal. It's like bringing back, Shoeless Joe Jackson to swear you in for your confirmation process. And I totally agree with you. I mean, the symbolism there, that was his first official act, is who's going to swear me in? And he chooses Emil Bovee, or to paraphrase Ty Cobb, who used to be Donald Trump's lawyer, God help us. We're screwed with Todd Blanche in that position. But the good news is Todd Blanche sucks at his job. I don't know how else to put this. And he had his first official press conference that you and I watched very, very closely as the Free Press started lobbing questions, many of which he looked ill-prepared to respond to. He often looks put upon. Like, I don't know how many times I have to answer this question. You can tell where he's getting his coaching from, he's got an audience of one in Donald Trump. But I thought it'd be fun to play a couple of clips and kind of get your reaction to it. You having been in the room and a lot of these reporters. So let's have our producer play a couple of the clips that we selected.
Next week, there's a deadline in the Comey case. The defense has said that there was evidence that was gathered by the government that suggested there were alternative reasons, sort of the restaurant narrative of 86. How confident are you today that case will survive to trial and ultimately result in a conviction?
So I'm not going to comment on a defense filing in any case, because that's not fair to any of the parties involved. And so I don't have a comment on the way that every case works in this country is that when every indicted case it means a grand jury has returned an indictment. That means that a grand jury found probable cause that a crime has been committed, and there's a trial. And there's a lot of cases as a prosecutor that I've felt were definitely going to get convictions, and that didn't, or that it was a tough conviction. There's cases that were really, really tough that got convictions, and so I'm certainly not going to act like I have a crystal ball and predict what's going to happen with that case at trial. But it's enough to say that this was a case that was returned by a grand jury. It's not out of D.C. It's out of.
Yeah, let's because you've been following the Comey case pretty closely. Even Pam Bondi refused to indict James Comey over the seashells, okay? Because she was still in office at that time. The fact that somebody wrote 8647 on the beach, and Comey commented about this interesting seashell collection on the beach and taking that as a true threat against the president. And isn't it the fact that for me, that Todd Blanche can't acknowledge or won't acknowledge, and nobody in the room will follow up with it, is that how much grand jury abuse there has been under his leadership, because even when he was the deputy attorney general or acting attorney general, a lot of grand jury abuse happened where they were lied to, where false testimony was provided in various grand juries. Grand juries refused to return indictments. And yet he says, well, it must be a good case because the grand jury returned an indictment. What did you make of that Comey crystal ball comment?
Well, let me focus on something pretty fundamental here. He was asked how confident he was that this case would go to trial and end in a conviction. And he didn't sound that confident. And by the way, so this is a sort of question that in any other circumstance is a total softball. And there's a prefabricated answer that I have heard 1,000 times from prosecutors not named Todd Blanche. And it's that the defendant is presumed innocent until proven guilty. We embrace that burden, but we would never bring a case that we are not confident that we couldn't prove beyond a reasonable doubt. He couldn't say any of those words. He couldn't honor his presumption of innocence, and he couldn't express any degree of confidence that this will survive to trial, because James Comey has a motion pending right now to dismiss the case on First Amendment grounds. This whole case hinges on this theory that 8647 is a true threat against the life of Donald Trump. And not only did James Comey not make that image, he took a photograph of seashells on a beach, that on the law it fails. He has a vindictive prosecution motion that could get rid of the thing. As you pointed out, there's a motion to go into the grand jury proceedings that could uncover all sorts of abuse. So my major reaction here is that Todd Blanche, when really tossed a softball by a reporter, a question that prosecutors get asked 100 times and has a prefabricated answer, he couldn't say I'm confident in it because he isn't confident in it.
Right. I think that is a perfect analysis of, all you got to say is I believe in the strength of our case, and we wouldn't have brought it if not. And but it literally, the softball bounced off his forehead. It was tossed. It was like boom. And but that is not. And you have a great video up on Legal AF YouTube channel about this kind of particular issue. But that wasn't the only rookie mistake that he's made, or where we could do an entire show just on this press conference. But let's play one more clip.
The reflective case, Katie Phang.
What about the reflective?
That's you guys to come forward and look at potential misdemeanor. Is there any update on where you guys are with that?
I don't know what you mean by the White House has asked us to do that, but no, I don't have an update on that. I think there's been a lot of comments and source-based comments about what, if anything's happening with that case. The judge ruled in that case, or we're waiting for the ruling, and I don't have an update. No.
Wait a minute. Wait, stop right there. Source-based comments. You mean people in the know inside the administration? Look, here's the reporting. You've done it. I've done it. It's out there. Donald Trump's unhappy with Jeanine Pirro, about to fire her. He's had proxies like Peter Navarro say things about Jeanine Pirro just recently on Steve Bannon's channel to try to crack the ice underneath her, and hopefully she falls through in their mind. There's already reporting that Jeanine Pirro went to the White House, made a presentation of the lack of evidence to support Davy Hearn's indictment. Okay, made a whole PowerPoint presentation to explain why she dropped the case. I think her only sin was she didn't apparently give the White House a heads up that she was going to do it, which, by the way, is a cardinal sin in any organization, that you don't give the top guy or the apex person the info so they get caught flat-footed. But there's also the new reporting that Donald Trump's unhappy. He's still selling this bullshit story about Davy Hearn violently ripping up 7 acres of cover of a liner and destroying the liner, and that he's pressuring the Department of Justice to bring an indictment. What you make of Todd Blanche's sort of, I don't even know what you're referring to.
So my favorite part of that entire clip was Todd Blanche pretending, I don't know what you're talking about with the White House asked us to do it. Okay, sure, Mr. Blanche. And this is me cartoonishly winking, as though you really have no idea that the White House has any involvement in this case against David Hearn, that everyone knows that Trump is fuming publicly about it, bringing Jeanine Pirro in the White House. This is a one time where he'll even pretend to have an iota of independence from the White House, and it just doesn't hold water. So the clip, there were many things that were just comical about it, but I think that was the biggest one, that he's pretending that he doesn't know the White House asked us to keep this bogus case alive, even after Jeanine Pirro put in writing that they don't have the evidence to convict, that he's not that David Hearn isn't the person to blame for the damage to the pool. This was another one of the really unconvincing responses from Blanche.
But it did remind me, I can't remember, it was at a press conference or one of his oversight hearings, where when I think it was the oversight hearing, when one of the senators or House members asked him about the Epstein investigations and said, can you give us an update on the Epstein investigations now that they've released all the files, or half the files, and the names that are in there and what you're doing about it? And he said, I don't understand what you're referring to when you say the Epstein investigation. Remember that?
I do. It's there should be a ranking of unconvincing things that Todd Blanche claims not to know about. I don't know about what Epstein investigation you're referring to.
This Constitution that you keep referring to, I'm not familiar with it.
Right. And doing his best Ted Lasso impression of, we're going to try our best with James Comey. Sometimes it's a tough case, and tacitly admitting that he's not confident in this case. Yeah. It's a bogus case. And that, we've now seen the investigation where FBI agents and others were furiously looking for any indication that some mobster anywhere used 86 to mean to kill, and they found the opposite.
Yeah, listen, I worked in a diner when I was studying for the bar. Okay, I worked fast food. I know what 86 means. When they tell you 86 to tuna fish, it doesn't mean take it out in the back and kill it. It means you're out of it and take it off the menu and stop selling it. That's what it's always meant. And the Comey case, just to stay there for a minute, has another little wrinkle. Because as you and I reported, another federal judge in D.C. about a First Amendment expression of a group that has been sitting out in front of, I forget which location that's, you may know it, which location this group has pitched a tent to call for the removal of Donald Trump. And they staffed this booth like 24/7. And they've had giant balloons that say 8647. And the Park Service tried to yank their permit. And a federal judge put a stop to it and did the whole analysis of 8647 and said that can never be seen as in this context, as a true threat against the president, and went through the whole, it came from soda jerks during the 1920s and 1930s. That case, even though it's not precedent in the Eastern District of North Carolina, it's certainly a well-reasoned decision that could be persuasive. And of course, Comey's lawyers have cited to it in some of their briefing, right?
Absolutely. And, I think it's just very clear to everyone watching that this is a case that is bound to collapse. And you don't want to get complacent. When the federal government uses the massive powers that it has to try to deprive a person of its liberty and gets federal prosecutors involved in that mission, you don't want to be complacent and say, well, surely it'll fall apart. Our system is strong. But this case has so many ridiculous flaws. The fact that that there is a Supreme Court precedent that if James Comey said, if Trump wants to send me to Iran, I'm going to put him in my sights, that would be analogous to what a Vietnam protester said about LBJ, and that the Supreme Court at the time said that was not a true threat. So the First Amendment grounds are strong, the vindictive prosecution grounds are strong, and many other defenses, selective prosecution. One of the things that we've talked about, Michael, is the fact that there are hundreds of products being sold on Amazon, 8647, 8645, and when Biden was in office, 8646. This is just part of the political lingo. And, we now have all of this evidence coming up that the FBI was trying to find some mobster anywhere to reinforce their theories, and they couldn't find a single person. They even went to, they went to Sammy the Bull, and Sammy the Bull said, go to this mob prosecutor, and the mob prosecutor, John Gleason, said that was absolutely ridiculous.
Right. And who's now a former federal judge, Gleason.
Absolutely.
Yeah. So let's stay on Blanche for a minute, and let's move to the Epstein records scandal. You've got a senior federal judge in the District of Columbia, Emmett Sullivan, who presides over a case brought by our friend Katie Phang against Todd Blanche in his official capacity. It's always Todd Blanche because Todd Blanche is the person under the Epstein File Transparency Act, or the Attorney General is the person, I should say, that is responsible for most of what needs to be done under the act. So if the act is not being complied with, you sue the Attorney General. And so we've gone now over a month with win after win after win by Katie Phang and her lawyers at Public Integrity Project, in which Sullivan issued effectively an order to show cause to say, all right, these 5 categories of documents, which is what she sued over so expertly, give me all the emails about the sex torture video. The fact that I even have to create that sentence is disgusting. Right. And the fact that it hasn't been revealed. Sex torture, give me all the evidence or the documents related to Donald Trump and a handwritten notes of the FBI related to a witness who says when she was 13, she was sexually abused. Where is the redaction log? And why haven't you translated the foreign language documents, even though I ordered you to do it? And lawyer after lawyer for the Department of Justice kept telling, in their own way, Judge Sullivan to go pound sand. We're ultimately not going to do it. We don't have to do it. We don't think we have to do it. We don't think you can tell us to do it. And worse to that effect. He's finally gotten fed up, and he hasn't yet, but he's about to lower the boom after this hearing tomorrow, where he wants the Department of Justice to come forward. It's not going to be Todd Blanche. The Department of Justice to come forward and give him evidence, to be an evidentiary hearing, as to each of the items there, and explain to him and show him documents as to why these documents are somehow not subject to being produced under the Epstein File Transparency Act. And there's going to have to be somebody who's going to have to stand and deliver for the Department of Justice. The biggest oddity for me is the sudden reappearance, not of Main Justice, because Stan Woodward, the acting number 2 in the Department of Justice, have been filing all these papers in the case. All of a sudden, the last paper in the case that got filed was by Jeanine Pirro's office, the U.S. Attorney for the District of Columbia. Now, is that because there's still an ethics person inside of the Department of Justice and they've taken Todd Blanche off of the case, so to speak, and they've given it to the District of Columbia to handle the defense of Todd Blanche? Like, what did you make of Jeanine Pirro's office and this poor, lowly assistant U.S. attorney making an appearance in the case, and I guess got the short straw is going to show up at tomorrow's hearing? What do you make of that?
Well, the Justice Department is headed toward a train wreck, and it's Jeanine Pirro's time in the barrel. I mean, look, this Thursday hearing, it's very easy to predict that the federal government is going to face a lot of headwinds, to put it mildly. You had Judge Sullivan say in an order before the hearing that they didn't comply with his order to provide him with information. He's asking basic questions like, why can't you redact a handwritten document? And, it just gets worse from there. And so the Justice Department has to know, and Todd Blanche has to know, that when the schedule for how this hearing is going to go down is Judge Sullivan saying you're not in compliance with my order and your rationalizations seem ridiculous, then okay, toss Pirro in the ring. This is, have her deal with this. This is not going to go well for them. And I don't make predictions as a journalist. I follow the public record, and the public record is blistering on this point. They know what they're walking into.
I totally agree with you. I think this is a total setup. This is like when Judge Brinkema in the Eastern District of Virginia greeted the one lawyer for the Department of Justice. That's all they sent in. Normally, I practice law. Normally you go to a major hearing, I'll have a couple of associates with me, maybe a partner and an associate with me, maybe a paralegal in the room as well. This poor person walked in on the Jan 6th Anti-Weaponization Fund legality, constitutionality, by himself. And the judge looked down at her nose on her glasses, Judge Brinkema, and said, "You are a very brave person."
Right. I remember us talking about
You were there. You reported on it. To come into my courtroom and make these arguments basically by yourself. And look, this next person who I never even heard of is going to show. I guess it's not going to be Stan Woodward. It's going to be this lowly assistant U.S. attorney who's going to show up tomorrow. You and I are going to phone in for it. You know, it's on the docket. You'll cover it. I'll cover it. And I almost feel sorry for them, although I don't. I think, and I've told this to people, don't be fooled by how, what's the word I'm looking for? How lacking in emotion the judge's order setting tomorrow's hearing up is. When you read it, it looks very dry, cut and dry, very plain vanilla. But I'm telling our audience, and I know you'll agree with me, that Judge Sullivan is seething behind the scenes. He'll get them into his courtroom. And I think this is going to be the start of lowering the boom on them. He's not happy that the foreign language documents have not been translated in an international child sex trafficking ring, despite his order. He's not happy with what they've produced, despite being given ample opportunity to produce. And I think this is a setup for a major contempt hearing.
Right. I mean, I think that Judge Sullivan has shown he's a tough judge. He's the judge who presided over the case of Michael Flynn, who said to the prosecutors, have you considered charging Michael Flynn with treason? He later walked that back, but he really showed that he was indignant about the crimes that Michael Flynn was charged with and pleaded guilty to. And he's been very systematically setting up his ducks in a row. He ordered the government to hand him the Epstein files at issue to inspect in camera. So all of this is following that. He's read the documents. He's seen their rationalizations. And he's said to the Trump DOJ, wait a minute, you're still not in compliance with my order. You are telling me that you can't redact handwritten documents. Why? And also, why is it that you're months late to filing your rationalizations for not releasing these documents on the Federal Register, as federal law obligates you to do? You know, as you said, Michael, it's very even keel in its delivery in this order, but those are, you know, read in their proper context, fighting words.
Oh, absolutely. When you put it in the context of knowing this judge and what he's previously ruled in this case, and how strong he's been in favor of the First Amendment and Katie Phang and the arguments that her lawyers from Public Integrity Project are making. We're going to, for those that are joining a little bit late or in progress, this is the Legal AF podcast. Don't adjust that dial. That is Adam Klasfeld of All Rise News sitting in as a guest anchor with me today. Michael Popok. All of his fine reporting and commentary can be found on All Rise News on Substack, and his video work on Legal AF YouTube channel. Just go to the playlist that we have, the playlist tab on Legal AF YouTube channel, and look for Adam Klasfeld, and you will find him there with all the work that he's done. He really is a can't miss type commentator out there at the intersection of law and politics. And so many different ways to support what we do here on Legal AF, the podcast. One, download the audio. I know that sounds slightly antiquated, but to be frank, it's the audio that still drives the algorithms and the ratings, and it keeps us at the top of the shows that on law and politics. And if that's where you want us to be, that's how you can help by free downloading. We made it easy for you with a QR code there as well. Then the Legal AF YouTube channel is sort of devoted to all things Legal AF. We just crossed 1.2 million subscribers. That's a big thank you to you, because without you, frankly, we would not exist. And we're at about 740 million views of our content, including Adam Klasfeld and me, Michael Popok. 1.2 million subscribers in less than 2 years. Really, we're just completely overwhelmed by the generosity of our audience, their time, their money, where it's appropriate, and the rest to keep independent commentary and journalism alive. So we got those are two things. We got a Legal AF Substack. There it is. We're now regularly in the top 5 of U.S. Politics Rising and top 30 overall. Move us into the top 10. You'll get 10 new pieces of content every day, including a live report that I do on a daily basis, only on Legal AF Substack, and all of the filings that we rely on, court opinions, Supreme Court opinions, motions, and this kind of thing are under Legal AF Substacks. We call it Filings AF. So those are a number of ways to support what we do. And then we've got our pro-democracy sponsors. We're going to take a break for them right now. When we come back, I've got a fascinating interview and exclusive briefing with the ACLU's Cody Woofsey, who runs the Immigration Rights Project for the American Civil Liberties Union, about a real-time event. The ACLU rushing into court in the last 24 hours up in New Hampshire with Judge LaPlante about birthright citizenship, again, to declare unconstitutional and in violation of the Supreme Court's ruling back in June in the case of Barbara versus Trump that established once and for all that birthright citizenship is enshrined in the Constitution in the 14th Amendment. Donald Trump apparently didn't get the memo, didn't read the opinion, doesn't want to acknowledge it, and issued new executive orders that violated the Supreme Court ruling already. So you're going to want to hear from Cody Woofsey when we come back from our commercial break. Thank you to our pro-democracy sponsors. And here's a word from them. Have you ever actually looked at the ingredient list on your dog's food? Well, after the first ingredient, good luck. Most kibble is made using extreme high heat to keep it shelf stable, which means brands have to add back synthetic vitamins and minerals with ingredients you can't even pronounce. Sundays for Dogs is different. They start with more than 80% all-natural meats, then add superfoods like kale, ginger, and blueberries, and gently air dry everything instead of using high heat. It doesn't look or smell like dog food. It looks like high-quality human-grade jerky. No fillers, no nutritional blends, no chemicals, just simple, complete nutrition. Founded by veterinarian Dr. Tori Waxman, Sundays was created to meet her high standards as both a veterinarian and a dog parent. And there's no fridge, no freezer, no prep, no mess, just scoop and serve. With over 100,000 dogs already eating Sundays, it's easy to see why so many picky eaters are excited for mealtime. Make the switch to Sundays. Go right now to sundaysfordogs.com/legalaf50 and get 50% off your first order. Or you can use code legalaf50 at checkout. That's 50% off your first order at sundaysfordogs.com/legalaf50. Or use code legalaf50 at checkout.
All right, let's be real. Who likes wearing a bra? Nobody, especially when you're working out, right? Sports bras are terrible to wear most of the time. And whether it's that they dig into your shoulders on the straps, or the band rolls up and feels too tight around your rib cage, or, whatever it is, they're a pain to put on, they're a pain to take off, and they're so uncomfortable. But Honeylove has this sports bra that is different. And they have this wonderful new product called the Honeylove CrossFlex Activity Bra. And it immediately felt different from every other sports bra that I've worn. It feels like a sports bra with a support, but it's also designed for all day wear, and it's supportive without feeling too tight, too stiff, or suffocating. It has easy to take on and take off, and it's wireless using their technology called Cloud Fuse. So there's no poking or digging or pressure points, which is actually what I love the most about it. And it gives you, of course, great shape and separation instead of that uniboob look that sports bras can often give you. So if you find yourself reaching for a sports bra on a daily basis, and because you need the coverage and you need the support, but you're looking for something comfortable that you could also wear all day, I highly recommend the Honeylove CrossFlex Activity Bra as the solution you've been searching for. So it's really fantastic. They are now offering a crossover triple bra bundle. So if you want a full refresh on your top drawer, you can get a huge savings by buying 3 at once. They are an independent female-founded brand with products designed by women who actually wear them, including the founder, Betsy. Honeylove doesn't just make bras and shapewear. They've built a full line of tanks, bodysuits, and underwear with supportive structure, smoothing fabrics, and premium finishes. And they recently launched their new crossover contour bra, which features their best-selling wireless crossover bra design, plus built-in molded light foam pads for extra support and beautifully contoured shape. Treat yourself to the most advanced bras and shapewear on the market. Use our exclusive link to save 20% off Honeylove at honeylove.com/legalaf. That's honeylove.com/legalaf. And after you check out, they'll ask where you heard about them. Please support our show and tell them Legal AF sent you. Experience the new standard in comfort and support with Honeylove.
Welcome back to Legal AF, the podcast, and thank you to our pro-democracy sponsors. And again, thank you to each one of you. It's your generosity that defines the Midas Touch and Legal AF community. I mean, as I've joked ad nauseum with my close friend and founder, Ben Meiselas, we would just be, two reasonably old guys, one older than the other, sitting on a park bench, feeding the pigeons and yelling at them if it wasn't for you and this community that we built that is so committed to the rule of law and defending our democracy. And I'm so honored to have our collaboration that we have with Legal AF and the American Civil Liberties Union, so that when a bombshell of a new filing happens or a new action by Donald Trump gets announced, such as his second run at attacking birthright citizenship, just hours after the Supreme Court issued its mandate to make final the ruling, at least 5-4 in the Barbara case from June, that birthright citizenship is enshrined in the 14th Amendment of the Constitution and not in a statute, and certainly it cannot be affected again by the executive orders, no matter how many they number. He could do 100 of them. I believe the ACLU wrote each one of them would be equally deficient under the Constitution. And right after he issued his two executive orders as diversionary tactics to try to take away from the fact that the Supreme Court, after 60 days, issued its mandate. Make me. Apparently is what Donald Trump believes his next response should be. And he issued two executive orders, one coming up with like a dozen new exemptions to birthright citizenship, missing the point of the 5-4 decision on the constitutionality of birthright citizenship written by Chief Justice Roberts, which was, no, we are effectively adopting a 1898 ruling from the Supreme Court in which we said there are only a couple of exceptions because birthright citizenship is sacred and sacrosanct and goes back before colonial period, stretching back to England. And so the Wong Kim Ark case came along, and we like those two exceptions, which are, ambassadors and other foreign entities, children, and a couple of 19th century Native American tribes. But that's it. Oh no, Donald didn't hear that. He said, I'm going to come up with a dozen more, people I don't like, and people that I declare to be foreign terrorists, and people that are participating in birth tourism, whatever that's supposed to mean, penalizing the babies that result from that and taking away their birthright citizenship. So right away, of course, two groups of plaintiffs that had cases, one in New Hampshire led by the American Civil Liberties Union and one down in Maryland in front of Judge Bortman, sprung back into action. I said, wait a minute, we got preliminary injunctions in these places against him doing exactly what he just said to do, that he's going to do. How do you map these exemptions onto our class of people that have just had babies or are about to have babies? And so when I saw that the American Civil Liberties Union in the lead case, because this jurisprudence now under the Supreme Court is known as the Barbara case, Barbara versus Trump, went back to Judge LaPlante, I immediately leapt into action and said, I got to get Cody Wolfsey on from the American Civil Liberties Union to join us here on Legal AF. So let's bring in Cody. Hi, Cody.
Hi, great to see you. Thanks for having me back.
Absolutely. People love you giving your exclusive briefing here on Legal AF and with the Legal AF YouTube channel, Cody being the deputy director of the Immigration Rights Project at the American Civil Liberties Union. And you came out really strongly about what the president just did in public statements. Why don't you catch our audience up about why you've returned to Judge LaPlante, what you're seeking, and how you, on behalf of your clients, the ACLU, interpret these two new executive orders.
Yeah, absolutely. I mean, if people are feeling kind of a sense of deja vu, haven't we already been here? You are not imagining things. You're absolutely right. The president, look, taking a step back, made his case to the Supreme Court. He said that he should be able to come up with new exceptions to this fundamental constitutional guarantee of birthright citizenship. And as you say, the court said emphatically, no. It confirmed what's been true, what we have always known, that if you're born in this country, you belong here. And that the only exceptions to that are narrow ones that go all the way back to the framing of the 14th Amendment, that are laid out in that, landmark decision that you referenced, Wong Kim Ark. And today, essentially, practically the only exception is for children of ambassadors who have full diplomatic immunity. But here we are again. The president is trying again to create new exceptions. And as we, laid out to the court, the answer is the same. The president cannot rewrite the Constitution. So what we've asked the court to do is we already have a certified class of all the babies who were subject to that first executive order. That is, babies born after February 20th of 2025 who don't have a parent who has permanent immigration status in the United States. And we just asked the court to say what the Supreme Court has already said. Those babies are citizens. President Trump cannot do anything to take away their citizenship. It is guaranteed by the Constitution. That is the motion we've put in. And, that reflects exactly what the Supreme Court declared just weeks ago.
Yeah, I mean, there's a certain amount of fatigue, but we are so pleased that the ACLU and the other groups have leapt back into action. I mean, it was the cleanest and fastest track back into a court to challenge those executive orders without having to avenge your lawsuits, because you have class members. You have a preliminary injunction, as does the other group, the CASA Incorporated group. And this is something that I wanted. I think this is a nice way for you and I to get a little inside baseball and give our audience something, a little bit of a mini law school class. If there's a violation of a Supreme Court rule, the law of the land now, the supreme law of the land. Some people might be thinking, well, just file a motion for contempt with the Supreme Court and point out on the record how these people aren't complying with it. But that's not how that works. And that's not how the Supreme Court likes things to come up to them. You got to start at the district court level and say, they are violating your law. And then it ends up at the Supreme Court, right?
Yeah, that's absolutely right. And, I think what we're talking about here is that the government may have some, arguments it wants to make, technicalities about this or that. But as you say, it's very clear. This new executive order is trying to strip away the citizenship of members of our class. And so, we think it's well within the court's discretion to say, no, you can't do that. It doesn't matter if it's based on Executive Order 1, Executive Order number 2, or as you say, Executive Order number 100. The rule the Supreme Court laid out is very clear. And so that's right. We're back in district court, and, we're hoping and expecting that the court will make very clear to the government that this is just as illegal.
Yeah, I mean, we've had, members of the ACLU who actually argued the case before the United States Supreme Court. And the thing that the takeaway for our audience is, look, some news outlets reported it as 6-3 because the great concurror, Brett Kavanaugh, concurred in the ruling, but not in the jurisprudential underpinnings, because he said, no, it's not a constitutional 14th Amendment thing. It's a Nationality Act, Congress Act thing. And then he had that very curious footnote, which obviously people in the Trump administration took to mean they could issue executive orders, which was Congress can create new exceptions that are not yet before the court, because his argument is it's not constitutionally protected. It's a statute that can be changed by an act of Congress. Whenever Donald Trump hears act of Congress can change it, somehow he always conflates that with, I'll do it by executive order.
Yeah, it's interesting. I do think, that the administration may be looking for some solace in Justice Kavanaugh's opinion. Obviously, on the constitutional question, that was a dissenting opinion. The majority took the opposite view from his. But I actually think when it comes to this executive order, there's no solace to be found in Justice Kavanaugh's views. And that's for a couple of reasons. So one is, he's very clear of what we're talking about. He says, I get it. Wong Kim Ark held that there is, quote, a closed set of exceptions to the citizenship clause. That's essentially today just children of ambassadors. And he also says, I think that very same rule, closed set of exceptions, was baked into the statute that Congress passed in 1940 and 1952. And that very statute guarantees the citizenship of, for example, the members of our class. And so on Justice Kavanaugh's view, this executive order is entirely illegal because of the statute. Now, it's true, Justice Kavanaugh thinks, it disagrees with Wong Kim Ark and thinks that there should be more exceptions under the Constitution, but he doesn't think there can be more exceptions under the statute. And he recognizes the Supreme Court majority disagreed with him on the constitutional analysis and accepted that there is a closed set. So any way you slice it, this executive order trying to come up with new exceptions outside that, quote, closed set is illegal.
No matter how many times he pulls the handle for Trump, it comes up lemon, lemon, lemon. And you've got 5 justices, including Amy Coney Barrett and Chief Justice Roberts, who aren't going anywhere anytime soon, certainly not Amy Coney Barrett. 5 justices say that it is a constitutionally protected sacred right, birthright citizenship. And if it comes back to that 5, it may be 5-4 again, but he doesn't have the votes. Yet that doesn't stop him from either pandering to his base for political reasons. Why do you think just to get into the mind of your adversary for a moment, why do you think Donald Trump issued those 2 executive orders on birthright citizenship?
I don't know. I can't.
Good answer.
I can't get into the head of another person, and certainly not the president. I will say, it may be that either the president or Stephen Miller or others in the administration are unhappy about the Supreme Court loss. Obviously, they've expressed that, and that they disagree with the Supreme Court decision reaffirming Wong Kim Ark and that fundamental right to birthright citizenship. But at the end of the day, that doesn't really matter. It doesn't give them any more power to inject themselves into this, really fundamental question of who counts as an American. And, just to take a step back, what are we talking about here? The point of the 14th Amendment Citizenship Clause, the reason that, those who fought and died in the Civil War, that the free Black communities who advocated for it, the reason that they pushed so hard to get this into the Constitution was because that they recognized that there's really 2 visions of America. There's an America in which if you're born here, you belong here. This is a multi-racial, multi-ethnic democracy. And then there's a vision that's reflected in the shameful Dred Scott decision, that's reflected in the anti-Asian racism that led to the Wong Kim Ark decision, and that is reflected in these executive orders that is attempting to exclude entire swaths of people from citizenship and full participation in our country because of who their parents are, and most fundamentally as a way to try and change the demographics of this country, make it whiter. And I just think the majority on the Supreme Court looked at this and saw it for exactly what it was, and the court said that the citizenship clause put, quote, the question of citizenship once and forever to rest. It was taking this out of the hands of politicians, whether they're in the White House or in Congress, and putting it in our most fundamental document, the Constitution. And that's why it doesn't really matter which actions the president decides to take or how he decides to slice and dice this. He has no power here. The Constitution is clear and the Supreme Court has already spoken.
Now, in your case, and before Judge LaPlante in New Hampshire, tell our audience what you've asked, what you filed, and what you've asked for, and the status of that, and then I can contrast that with what's happening in Maryland with Judge Boardman.
Absolutely. So, we filed a few things, some procedural motions, but the primary thing we filed is this. We said, we think that this executive order already violates your injunction. That injunction bars the president, the executive branch, from taking away citizenship from anybody in our class, who again is all those babies subject to the first executive order. But we said, look, if there's any question about that, you can clarify that that's what the injunction means. You can modify the injunction to change the wording slightly to make sure that it is protecting these class members from any sorts of attacks from the executive, whether or not they are sort of grounded on that first executive order. Or you could issue a new preliminary injunction. Whatever you do, the point is our class members are facing the exact same threat they've always faced in this litigation, which is President Trump denying them their birthright as U.S. citizens. The court has already decided the preliminary injunction. The First Circuit agreed and affirmed it in another case. And the Supreme Court obviously has now agreed and affirmed as well. The legal questions are done. And so, all that really remains is to make sure that our clients' rights are being enforced. And
so in Judge Boardman's courtroom, they've already gotten a little bit of information out there because the plaintiffs there reached out to the government and said, we can't make heads or, I'm paraphrasing, we can't make heads or tails of your executive orders. They're very ambiguous and murky at best. Can you clarify what some of these terms mean and whether, so we can map it on to our preliminary injunction lawsuit? And the response was sort of like, we're not going to clarify. We think it's too early to have to do that. It's prospective only. So don't worry about babies born before. And we're still working on guidelines. What did you make of this sort of new color and intel that they got in that case and how it impacts yours?
Yeah, I think that we completely agree that the executive order raises 1,001 questions that it doesn't answer. And we've laid out some of those to the court as well. For example, the original executive order from last year specifically said this is going to apply moving forward to babies born February 20th, 2025 and forward. So it's not going to apply to people, say, who were born last year, 10 years ago, 50 years ago. But the new executive order doesn't say that. And so it opened up the obvious possibility that actually what they were saying is we're going to strip away citizenship from who knows how many people who have lived their entire lives as citizens, not just attacking babies moving forward. So it's not surprising to me the government is, going to take some positions, attempting to narrow this executive order to make it less cruel and extreme. We'll have to see kind of how that shakes out in terms of what the ultimate scope of this new executive order is. Obviously, that is going to matter for the twists and turns of this litigation. But I think the thing for people to understand is really two things. Number one, ultimately, these questions about the scope don't matter for the merits of this executive order, because for all the reasons we've laid out to the court, the order's illegal under the Supreme Court's decision already. And whether it applies prospectively, retrospectively, what have you, it's illegal. But the second point is, I know that there's a lot of folks who are confused. There's quite a few folks who are scared about what this order might mean for their citizenship, their children's citizenship, their families. And, as I said, there's a lot of questions raised by the executive order, and we and the other groups litigating these issues are working hard to get clarity and answers and protections in place. But ultimately, we already fought the big fight here because the Supreme Court has already confirmed that the Citizenship Clause means what it says. And so part of this is just about how are we going to get, to a place where there's court orders, protecting everyone who is a birthright citizen from these lawless actions, as opposed to where we were, say, a year ago, where the goal was really, the government was trying to get this issue up to the Supreme Court and rewrite that fundamental rule.
Absolutely. And even the one on birth tourism, which, panders to his base. I mean, this is just my view. You want to make illegal this industry to the extent that it's even a real problem in America. I'm not sure how many dozens of people actually come to America in order to have a baby. But let's say you want to criminalize that in some way. That's different than criminalizing it, than stripping away, if there is a baby born from whatever you have deemed to be birth tourism, and good luck with that, the baby can't lose his or her birthright citizenship because of this illegal conduct. You can make it illegal, right? You can try to police it, but you can't, if despite all of that, there is a baby born, that baby's a U.S. citizen.
Yeah, that's absolutely right. I mean, a few things I'd say on this. So one is, I totally agree. This is a red herring that is used for political purposes. All the data show that this idea of, people coming here specifically to give birth on a tourist visa or whatever is a, tiny, tiny fraction of all births. The second thing is it's already barred under federal law. There's a federal regulation speaking directly to this. And in fact, a DHS representative told the New York Times that this executive order really doesn't do anything. It just repeats what current law already is. But number three, I think you're completely right. So much of the first and second executive order is about trying to blame children, babies, for what the administration perceives as sort of the sins of their parents. But that is actually really fundamentally contrary to American values. There was a doctrine about, sort of imputing crimes of the father to children under, English law. And that's one of the things that's explicitly rejected in the U.S. Constitution, because in this country, every person is their own person, and every child born here is a citizen. That's why the Citizenship Clause doesn't say anything about people's parents. It says if you're born in this country and you're subject to the jurisdiction of the country, you're subject to the country's power, unlike, say, a child who has diplomatic immunity, then you are a U.S. citizen.
Really appreciate, Cody, you coming on with us on a regular basis to make what appears at first blush to be complicated really easy to understand, and make our audience feel great about the fact that the American Civil Liberties Union and all of its, different divisions. I know you're working with the ACLU of New Hampshire and the ACLU of Maine and all different parts of the ACLU. As we end here on this segment of Legal AF, just talk to our audience about what your Immigration Rights Project does, and sort of explain how the ACLU, kind of the national umbrella organization, works with its local affiliates in cases like this.
Yeah, absolutely. I'll start with the second part first. Our affiliates are really the engine that powers our ability to do the work that we do across the country. We have affiliates in every state, as well as DC and Puerto Rico. And, they are doing the work day in and day out, litigating on all the different issues that the ACLU works on, whether it's immigrants' rights, reproductive justice, criminal justice reform, racial justice, the voting rights, the list goes on and on and on. They're in state courts and federal courts. They're in our state legislatures lobbying, and they are in the communities kind of building coalitions. And so we work with them hand in hand in cases. I think this is a good example of what that partnership can yield. I can't say enough good things about our affiliate colleagues. We at the Immigrants' Rights Project work on a wide range of issues in terms of the constitutional and civil rights of non-citizens and their families. Right now, we are fighting back against the most anti-immigrant administration in our lifetimes and possibly ever. And so in 1,001 ways, we are trying to push back against the anti-immigrant and anti-mixed status family agenda of Stephen Miller and the rest of the administration. I'll just name a couple of things that we're doing. We are fighting back against the Shameful Alien Enemies Act invocation, which is trying to completely eliminate any semblance of due process for people and shove people out of the country without a hearing based on the flimsiest of evidence. We're fighting back against mass detention, which the administration is trying to use in order to essentially bully people into giving up their chance for asylum or other kinds of protection by keeping them in horrible conditions in immigration detention indefinitely without even so much as a bond hearing. And we're fighting back against various state laws that are trying to bolster the Trump deportation agenda, as well as set themselves up to fight against, for example, the next Democratic administration, which might have a different view on immigration policy. So we're doing it all. Our affiliate colleagues, our colleagues in communications and advocacy are doing it all, as are our partners across the entire movement. And we welcome people joining our efforts in any way that they can. Visit our website, aclu.org, go out and join those protests, give to local organizations working on immigrants' rights issues and immigration representation. We need your help.
Yeah, we'll put actually the link below for the ACLU for those who want to help and join. There's so many different ways to do it, not just money and donations, which is great, but also getting involved and joining local affiliates or the national organization. I know there's so many different ways for people to get involved with the ACLU, and we're so honored to have you regularly here and collaborating with us on Legal AF. Cody Woofsy of the American Civil Liberties Union, thanks for joining Legal AF, the podcast tonight, to brief our audience about birthright citizenship.
Thanks so much for having me.
And thank you to Cody Woofsy and the American Civil Liberties Union. We so appreciate their collaboration on the Legal AF YouTube channel. Whenever we have the opportunity to get the ACLU on to talk about their cases, they've got hundreds and hundreds of cases that they have filed to defend American values, to defend the First Amendment and the Constitution, immigration rights, civil liberties, civil rights. ACLU is on the front lines in the courtrooms. And when we can get their lawyers to come on and others to talk about their cases, we jump at that opportunity. Let's bring Adam Klasfeld back on as well. Adam, you do a fair amount of ACLU interviews as well.
Absolutely. They're behind some of the biggest cases that are out there. We were talking about in your conversation with Mr. Woofsy, it's the Trump executive order in Birthright Citizenship, and they were behind the original Trump v. Barbara case. And I was there in New Hampshire when that was going down. So I'm constantly—
You're going back to New Hampshire, my friend.
Well, yeah, we will see when that comes to a head. But
yeah.
Judge LaPlante. Judge LaPlante. I'm sorry.
Go ahead. Talk about LaPlante, because you've been in the courtroom.
Yeah, I mean, he ruled from the bench that time. I think that this is going to come to a head before him. I think he's a tough judge, and reading their papers in this, I want to read a line that just kind of gets to the heart of it. They wrote, "If the president issues 100 orders seeking to create new exceptions to the sacred guarantee of the Citizenship Clause, all 100 will be equally illegal, and nothing requires this court to countenance the continued assault on this foundational constitutional principle or issue an endless string of EO-specific injunctions. I don't think...
Yeah. They're not going to do better with Boardman either in the Casa case.
Absolutely. This is just a sort of thing where it's what Trump always does. He loses in the Supreme Court on tariffs, so he tries to wriggle it around with a different legal rationale. Here, there's not even a different legal rationale. He's trying to define words differently and try to relitigate an issue that has been resolved. It's unconstitutional. So here we are again.
Yeah. Now, Adam, you're in the business of reporting and breaking stories and investigative reporting and bringing your commentary. Have you ever thought about scraping up $100,000 a month so you can get insider access before the rest of us to postings by the press secretary and Donald Trump, J.D. Vance, and the FBI and the Treasury Department, and RFK Jr., so you can get insider information so you can trade on it, you can invest around it, and you can make business strategic decisions? Have you ever thought about doing that?
Well, when I sleep on a bed of money that I could shovel to Donald Trump like that, of course not. It's, and I know what that transition is, Popok, and it's a good one. This lawsuit against this scheme where Trump is, through Truth Social, offering access to Wall Street insiders to get, in his words, market-moving posts, advance access to that.
Wait, stop right there. Back in the day, that used to be called front running and insider information, tippee, and that's a bad thing. The fact that Trump is selling just through his Truth Social official government information early to people on purpose so that they can imagine if you and I knew that the Transportation Department was about to announce a new contract to make an investment in build a new bridge in fill in the blank. Okay. You and I would, if we had that information, we would buy up all the real estate around that area, or we would invest in money in the contractors. Or if we knew that he was about to bomb Iran or take over Venezuela early, we would shift our portfolio towards industries that support that issue, which is exactly what Trump he's basically admitting that he's been front running all this time. And now he's offering that to the average $100,000 a month paying subscriber. The thing that galls me, and then I'll turn it over to you to complete the whole lawsuit that's been filed, is that he's the first one to come out and say that Jack Smith was wrong about why he kept the Mar-a-Lago documents. Because there was a working theory that Jack Smith had as special prosecutor, independent prosecutor, that Trump would kept all of those top secret classified documents and war plans because he wanted to sell them and make money off of them. Isn't this effectively an acknowledgement that that's exactly what Donald Trump thinks is okay?
It's an admission. That's a great tie there, Popok. I think they are related issues, that he does think that information can be profitable. And he's right about that. There's public reporting that there are 10 people who took him up, or took Trump Media, which owns Truth Social, up on that offer. And they're paying, in effect, more than $1 million a year. And I think the statistic is more than 10 people. So at a minimum, it's tens of millions of dollars at the very beginning that he's getting, selling early access to public pronouncements. And he's contractually obligated to make those official announcements on his social media website. So as you said, if there is a military action, if there's a domestic policy, if he's making an appointment, that goes there, and his Wall Street buddies get access to it first. And so this lawsuit that was filed, that I find really interesting, and it was a perfect way to open it the way you did, Popok, is that he said, the lawsuit says this is a First Amendment issue. One of the plaintiffs is The Intercept, a news organization. The other is the Freedom of the Press Foundation. And what they're saying is these Wall Street buddies who cannot buy early access to public announcements from the president of the United States before the press and public does. So they're making a First Amendment case about it. And in the meantime, you have Capitol Hill taking action. You have Congressman Jamie Raskin going ahead and saying that he's launching an investigation, which would have a lot more teeth if he gets subpoena power after the midterm elections, but we can talk about that later. We have a proposed bill in the Senate by Senator Reid, and again, if the Democrats take the Senate, then we can talk about even the possibility, the question of that advancing. But this lawsuit goes from the fundamental premise is that set aside the self-dealing, set aside the corruption, set aside the insider trading. There's a core First Amendment issue. They also say the Fifth Amendment is one of the basis of their claims, and they filed this in my backyard in Lower Manhattan, the Southern District of New York. I think this is going to be one of the big First Amendment legal battles, and it's the same court where Trump faced a lawsuit in his first term about blocking people on Twitter. If that was a First Amendment issue and it was determined to be a First Amendment issue in that court, I don't see how he's going to avoid the conclusion that this is a First Amendment violation to hope to make the press and public pay $100,000 a month to get early access to what should be public information.
And how about when we talk about the stock market and how you could trade on that information and make strategic investments? What about all the predictive markets? What about Polymarket? What about Kalshi? What about people that made money because they got tipped off that we were going to take over Venezuela and bet on that and made millions of dollars? Now for your $100,000 a month, you can go into all these predictive markets and you, right? Because you've got the earlier information than anybody else. And the fact, and look at the list of people. This is what I loved about the lawsuit. They were like, Trump sends out information on his social media, on his own Truth Social, about foreign policy, domestic policy, military policy, economic policy, in this case, RFK Jr., public health policy, transportation policy, the press secretary. We know that Carolyn Levitt is, she came back off like a maternity leave, and now she's already quitting. But whatever, she's going to spend more time with her family. But whoever the press secretary, communications director is, right, is, and the FBI director, and think about this FBI director, Kash Patel, who is so like a bull in a china shop with information. You get this information early. I don't understand what the defense is going to be by the lawyers. I'm sure it's going to be Sullivan and Cromwell. Get ready, representing Truth Social, or this lawyer at DLA Piper, Chris Operson. One of them is going to be, will be representing Donald Trump's interest in this case. Might be Operson, but maybe the Department of Justice intervenes. I mean, how are they going to justify to a judge the selling and front running of insider public information early to people that pay for it? I just don't understand.
Well, they'll try to find some sort of procedural dodge. That's what they always do. It's going to be, oh, you filed too early or you filed too late. We will see what they try to throw at a federal judge to try to avert injunction blocking them. But to your point about predictive markets and the whole Wild West economy surrounding that, I remember the days when we just called those gambling sites, and there are people who have been prosecuted for it within, who had early access to government information and tried to bet it on some of these gambling sites. And, we're speaking a day after an unexpected result in the Wisconsin gubernatorial elections, where one of those quote unquote predictive markets thought that the losing candidate had a 95% chance of winning. So what we have here is a recipe for anyone who has a spare $100,000 a month to shell out can use that information to get an edge on the stock market, to get an edge on the gambling market. It's a kind of thicket and bog and septic tank of conflicts and corruption. And, who knew that the first lawsuit against that wouldn't be about insider trading, wouldn't be about emoluments, wouldn't be about corruption. It's about the fundamental issue, the First Amendment. The President of the United States using his private website and using it and through contractual obligations, he's giving it early to the public there, and that he's setting aside the advance access for his Wall Street buddies.
Absolutely. Well, that is a business model. It's just not Legal AF and Midas Touch's business model. We don't try to charge a small group of people $100,000 a month for early access to our videos. We just ask for support in a completely different way, and one that I hope that everyone feels is comfortable and appropriate and consistent with our ethos and our values. So many different ways to support what we do here on Legal AF, starting with the audio downloads for this particular podcast. Then you've got the Legal AF YouTube channel. And thank you, an early thank you. We just crossed, literally in the last few hours, 1.2 million subscribers. We rolled the odometer, all because of you and your generosity of spirit and commitment to what we do. Our First Amendment rights are stronger because you are protecting your own by supporting what we do on Legal AF, the YouTube channel. Legal AF, the Substack, is another great community. You can get in on the ground floor. Some people might be thinking, oh, wow, I just recently joined Legal AF YouTube channel. I'm on the 1 millionth person. Well, you can come. We got about 165,000 people or so that have joined Legal AF Substack. You get about a dozen new pieces of content every day, including our videos. You like Adam Klasfeld of All Rise News, who's my co-anchor tonight. You're going to love him when he joins us on a regular basis on my live reports on Substack and only on Substack. And then we've got our pro-democracy sponsors, some of which have been with us from the very beginning, like 6 years ago when Ben and I co-founded Legal AF. Some are new, but they have something in common. They know they don't know what we're going to say, but they know what our point of view is. They know what our viewpoint is and our commitment to honest commentary. They know what our audience is all about, and they want to be here in support. So disposable income is a tough thing to come by these days with Donald Trump in office, but these are products that Jordy and I have vetted, Jordy, one of the brothers, of course, for the Legal AF. And these are things we think are interesting. And if you think they're interesting, take a shot. And that's another way to support what we do here on Legal AF. So let's take a break for our pro-democracy sponsors. This episode is brought to you by IQ Bar, our exclusive snack, hydration, and coffee sponsor. IQ Bar protein bars, IQ Mix hydration mixes, and IQ Joe mushroom coffees are the delicious, low-sugar brain and body fuel you need to win your day. I like having convenient, better-for-you options on hand, and IQ Bar makes that easy. The Ultimate Sampler Pack is a great way to try everything. You get 9 IQ Bars, 8 IQ Mix sticks, and 4 IQ Joe sticks. Plus, all IQ Bar products are clean label certified and entirely free from gluten, dairy, soy, GMOs, and artificial ingredients. With over 20,000 five-star reviews and counting, more people than ever are fueling their busy lifestyles with IQ Bar's brain and body boosting bars, hydration mixes, and mushroom coffees. Their ultimate sampler pack includes all three. And right now, IQ Bar is offering our special podcast listeners 20% off all IQ Bar products, including the ultimate sampler pack, plus free shipping. To get your 20% off, text Legal AF to 64,000. Text Legal AF to 64,000. One more time. That's Legal AF to 64,000. Message and data rates may apply. See terms for details. Have you ever thought I should really be doing something to protect myself from stalkers, scammers, and hackers, but you're not sure what? Here's what to do. Go to www.joindeleteme.com/legalaf and enter code legalaf. You'll get 20% off Delete Me. Delete Me removes your personal information that's being sold online. Look, I have an active online presence, so privacy is really important to me. Knowing Delete Me does the hard work of removing my information from hundreds of data broker websites gives me real peace of mind. Take control of your data and keep your private life private by signing up for Delete Me. Now, with a special discount for our listeners, get 20% off your Delete Me plan when you go to joindeleteme.com/legalaf and use promo code legalaf at checkout. The only way to get 20% off, though, is to go to www.joindeleteme.com/legalaf and enter code legalaf at checkout. And thank you to our pro-democracy sponsors. Welcome back to Legal AF at the midweek with Michael Popok and guest anchor Adam Klasfeld of All Rise News. If this is your first time hearing or seeing Adam Klasfeld, you can follow him on Substack on All Rise News. He regularly appears on Legal AF YouTube channel. You can look for his playlist there. And in the notes below, we'll give you the links for all of his social media and Substacks that you can consider becoming a subscriber. I think it's must see YouTube, must read Substack whenever Adam Klasfeld's name's attached to something. Really appreciate you being here, Adam, with us today. Why don't we bring it home with John O. Brennan, former CIA director for Donald Trump, apparently the subject of not one, but two federal grand juries. One that I know of in particular is what we refer to as the Grand Conspiracy grand jury, which is presided over by your friend and mine, Aileen Cannon, the judge in the northern hinterland of the Southern District of Florida in Fort Pierce, Florida, infamous for presiding over the Mar-a-Lago case and chastising Jack Smith whenever she had the chance and turning the tables and proving that somehow the prosecutors were the bad people and Donald Trump was the good people, and has locked away forevermore the report of Jack Smith related to the Mar-a-Lago case. Putting that aside for a minute, that's also being apparently prosecuted by a special employee appointed by Todd Blanche named Joe DeGeneva, who's an 82-year-old former Reagan U.S. attorney. He was the Jeanine Pirro of the D.C. U.S. Attorney's Office in the Reagan era. And he's been, you just put in Joe DeGeneva or his wife, Victoria Tensing, and just put that into Google, and you'll see these crazy clips of him on Newsmax and Fox News attacking John Brennan, attacking Comey like a decade ago about their involvement with a mass conspiracy to have Donald Trump defeated at the polls in collusion, I guess, with the Russians or whatever. So he's in charge there. Blanche appointed him. And John O'Brennan is not waiting around to see if he's going to get indicted or not. He keeps filing motions with the district court judge in the D.C. accusing the Trump administration of potentially destroying evidence. I love the fact that he's not sitting idly by and just waiting. I wonder if I'll be indicted today. Right. He's actively suing first before the indictment, setting up his future motion to dismiss for vindictive prosecution, et cetera. Let me turn it over to Adam Klasfeld about the new filing that we're reporting on.
That's a great introduction, great setup, because like others who were targeted by Trump, you have Brennan being proactive. Remember when Jay Powell saw that there was this grand jury investigation, he went to quash the subpoenas and succeeded. And so what Brennan is doing, he's not trusting that the Trump Justice Department is going to dutifully preserve evidence to protect his due process rights before an inevitable indictment, as he sees it, because Trump demanded it. If Trump demands it, if you're on his enemies list, if this has been openly declared, we know where these investigations are going, especially if they're in the courtroom of Trump's favorite judge, Aileen Cannon. So he, as you said, Popok just came out with a new filing. I'm going to read from the introduction of it, 32 pages long, but the introduction kind of lays out the basic point that he is asking the court to have the government honor its obligations, which is to preserve evidence that could be used against him at trial. And he makes a very simple point that if the government is fighting this hard against him in that effort, that's more of a reason for the court to take action. Here's what he says. Former CIA Director John Brennan is currently the target of 2 federal grand jury investigations, which are demonstrably motivated by President Trump's effort to use the criminal justice system to seek retribution against Director Brennan for his lawful conduct while serving as CIA Director and for his criticism of the president in the years since. To ensure he can effectively challenge any unconstitutionally vindictive and selective criminal charges, Director Brennan has sought injunctive relief, ordering the government defendants to preserve the internal government records and communications that demonstrate the retributive motivations behind an eventual prosecution. In filing this action, Director Brennan seeks nothing more than to ensure that the government does what it is already obligated to do: preserve all records and communications relevant to the government's preordained decision to investigate and prosecute him. Rather than simply stipulating to uphold that constitutional obligation, however, the defendants devote their responsive pleadings to arguing the limits of that obligation and disputing when and how Director Brennan has the right to enforce it. So that's where the rubber hits the road here. You have Brennan pointing out that the entire premise of his legal action is government, preserve your records. That if you are going to go ahead and do this vindictive prosecution, I'm going to have a fair trial, and I need a judge to protect my rights because you can't trust this administration to do it. And what does the government do? It fights it tooth and nail. And he argues in this 32-page motion that their recalcitrance is the reason the judge has to take action.
Absolutely. I mean, this is a precursor. I mean, there's a number of ways if you're on the receiving end of a vindictive prosecution of the Trump administration Department of Justice that you can conduct yourself. You and I have covered many of them. If you're Kilmer Abrego Garcia, that poor guy from Maryland that became the poster child for civil liberties abuse by Donald Trump and being sent to the torture prison of El Salvador without due process, and then having a trumped up criminal charge against him in order to bring him back to the United States. If you're him and you're those lawyers, you don't preemptively file anything, although in a way you do, because they filed their civil rights case in front of Judge Zinnes, although that led to the criminal case. But when things are developed more, then you file your motion for vindictive prosecution. You don't file preemptive motions. That's one way. If you're James Comey, the first indictment that was brought by Lindsay Halligan, you don't do anything to cut off Lindsay Halligan at the pass. You just let it play out. And then once it plays out, you immediately go for the grand jury transcript and you file your motion for vindictive prosecution and you get judges to rule on it at that time. That's a way. And if you're James Comey the second time, you don't file early. You file it when the grand jury indicts, and then you start building your case again to get your case dismissed. But what I love about John O'Brien is rather than sit around for this amorphous, rogue grand jury, Lord knows what Joe DeGeneva is telling the grand jury in order to get an indictment. I mean, given the track record of this Department of Justice in abusing the grand jury process, in suborning perjury, in sending in false testimony, in misstating the Constitution, in sending in fake documents, Lord knows what crazy Joe DeGeneva is telling a grand jury. And so rather than wait around and find out and to have this shadow, this shade over him, John O'Brien, he filed first. This is now like the second or third motion that he's filed in a different court arguing against indictments. Lord knows where they are. So I like the tact. It's not for everybody. It's not for the faint of heart either. It's a strategy that they developed that it's bespoke. It works for John Brennan because of the nature of the double indict, the grand juries and the Geneva and all. It works. And it's really, but it's not for the faint of heart. Not if you ran that strategy past a dozen top flight criminal defense lawyers that do work like this, at least 10 of them would say, pass. That's not how we're going to do this case. So I give them a lot of credit.
Right. And it's also not for folks who can't afford the crushing expense to litigate on multi fronts. And, there's that expression, you can beat the rap, but can you beat the ride? There's a ride going on where he's having to litigate in civil court. He believes that it's inevitable that he's going to have to litigate in federal court in a criminal case. And that this strategy in saying that I don't trust the Trump Justice Department to preserve records and give me information that is exculpatory and necessary for my defense. Well, there's a history behind that. Right now, or around the same time that this is going on, the Southern Poverty Law Center is saying that the Trump Justice Department is withholding evidence of its longstanding cooperation with the FBI using information about it from its informants program to share cooperatively with the federal government. Years and decades of this cooperation that's memorialized in government files that the government isn't sharing. So I think Brennan knows that this is necessary to defend himself. And to take a step back from all of this, we've talked about the grand conspiracy investigation, quote unquote. And it's worth emphasizing just how ridiculous this Joe DeGenova investigation in the Southern District of Florida in Fort Pierce is. It's based on this conspiracy theory that dating even before Trump's first term, there was some sort of coordinated conspiracy between enemies of Donald Trump from before the Mueller investigation, spanning through the Mueller investigation, spanning through Trump's criminal prosecutions after his first term against him. And that this somehow thwarts the statute of limitations because it's ongoing with different actors that are in the deep state. Now, this is something that is in the kind of crazy waters of Mike Lindell podcasts, but now it's actually in a federal court. Now it's actually in the courtroom of Judge Aileen Cannon, where it's, for anyone who's been there in Fort Pierce, and I was there covering Trump's criminal case, it's a tiny courtroom. You're not allowed to bring electronic devices. It's basically a black box that will have a pretty limited audience if this grand conspiracy case gets off the ground. So he has to be aggressive because in a circumstance like this, even a crazy investigation like this, the deck appears to be really stacked.
Yeah, two quick observations. One, I've tried a case in that Fort Pierce courthouse. I used to practice out of West Palm Beach, and I covered the entire Southern District in early in my career. And then secondly, if you're talking about the crazy water, you and I have done separate hot takes about Donald Trump's. You want to read about the deep state and and you think this is batshit crazy? Just read Peter Ticketon, Donald Trump's former military academy roommate from high school, who's one of their go-to lawyers. He's represented Tina Peters, all sorts of things. He just filed a federal Tort Claims Act case on behalf of a dozen Jan 6ers, including a Proud Boy who was convicted of seditious conspiracy, looking for money from the government. But it's not just like a plain and simple under Rule 8 of the Federal Rules of Civil Procedure statement of the claim. Oh no, it's 30 pages of deep state QAnon, already debunked 80 times in federal courthouses, just mad as a hatter shit about globalists and anarchists and the Democratic Party and the grand conspiracy, and this is the reason why Donald and the election was rigged, and the software companies and the hardware companies. Like, if you thought Sidney Powell was mad as a hatter. Wait till you read what Peter Ticketon has wrote. I have it up on Legal AF Substack on behalf of Jan Sixers to try to get their money. But this is the problem. These are articles of faith for those that surround themselves and make money off of Donald Trump. So whether it's Joe DeGeneva or it's Peter Ticketon or it's people now inside the government that were once outside the government, like Stan Woodward and Todd Blanche and all Donald Trump's personal criminal defense team or his outside criminal defense team, they've all drank from the Kool-Aid jar container that relates to Donald Trump. And they believe at least most of the gospel of this bullshit about the 2020 election and Donald Trump being crucified by something called the deep state. So if you ever can't go to sleep at night, you got to read Peter Ticketon's complaint. But these are the people that Donald Trump have empowered who enable his worst instincts, right?
Right. And to your point, they filed this in the District of DC, where I can guarantee you there isn't a single judge on that bench. These are the judges that presided over the January 6th docket, who saw all the videos of the rioters beating up cops. They're the ones who presided over the seditious conspiracy trials. Even every Trump appointee, every Biden appointee, every single appointee in that court knows that this kind of conspiratorial nonsense peddled in this complaint is malicious garbage. They did not file this complaint thinking that this is going to be a winning lawsuit. They filed this complaint because this is the administration that wanted to do the payout pot for punks, as Tillis called it, and that they know that if they file the complaint, the Trump Justice Department is going to roll over, because any judge in the court where they filed this that looks at this complaint will have to suppress his or her gag reflex.
So well put. One of the many reasons I was looking forward to doing the show tonight is just having your insightful wit and analysis. Adam Klasfeld, All Rise News, joining as a guest anchor today on the Legal AF podcast. Thank you for taking time out of your day, Adam, to brief our audience. And for those that know Adam, I'm sure they've been thrilled. For those that are just being introduced to Adam, in the links below, you'll find links to All Rise News and different ways to support his independent commentary and journalism. Thanks for being here on Legal AF, the podcast. Download the audio. So many different ways to support what we do. Download our audio. QR code is up there for you. It sounds antiquated and analog, but audio podcasting is still one of the drivers for ratings. So even if you're a YouTuber like I am, go over to the audio podcast and do us a favor and hit subscribe and download. Leave us a 5-star review. Come over to Legal AF YouTube channel. Thank you to everybody. We hit 1.2 million subscribers right on time, less than 2 years up and running. And that's a compliment to our audience and their fervent support for what we do. 12 new videos a day. We call them 12 hot ones a day over on Legal AF YouTube channel. Cost you nothing to subscribe, but it means the world to us and what we do here on supporting independent journalism. So you've got those two major ways. Of course, we've got our pro-democracy sponsors, and you're talking about supporting independent commentary and journalism. You can, I can't think of anybody finer to help support than Adam Klasfeld of All Rise News. Thanks for being here again with us, Adam. And you get to be here. It's sort of like Saturday Night Live when they do that whole intro, then they go live. It's Saturday Night Live. We have an ending you get to be a part of here on the Legal AF podcast. You ready? Here it goes.
Yep.
Shout out to the Mighty and the Legal AFers.